Yes.
Can I permit to mention one matter? It's parted matter, my lord.
We'll see.
Both are, my lord, respondents before this one.
Yes, we'll see.
My lord, rather parted matter I submitted in front of the Dharwad.
It is not listed, that matter. I told to post all parted matters. Just find out if it is tomorrow, that matter tomorrow. Give that. Anita? All these memos to the chamber in the afternoon. Then we will see. Take all the memos.
Page wise adjournment, page number 3, cell number 8 to 14, page number 4, cell number 15 to 20, page number 5,
Page number?
cell number 18.
18 months. I am appearing on prosecuting counsel on behalf of the petitioner counsel, my lordship. And I have it on tomorrow, my lordship.
Tomorrow. Tomorrow, I don't think how it's, tomorrow.
Please.
Page number 5, cell number 21 to 26,
Millard, serial number 23 Millard. Price on short accommodation Millard. Next date
Why?
month senior out of station of next date month.
Have you informed the other side?
Vignesh Shetty.
Next
Yes,
date
will
month.
this matter after 2 weeks?
Grateful Millard.
Which matter?
23.
My lord, some urgency.
Page number
Which one?
23.
23. That's not your matter, FC.
G. Ramana,
Petitioner.
Harish
Yes.
HV.
Yes.
Page number 6, cell number 27 to 31, page number 7,
My lord.
33.
Serial number 28, my lord.
Hmm.
I have a respondent in this case, my lord.
Hmm.
Senior is not well. He is admitted in hospital and ICU.
This is matter after 4 weeks.
On submission, I am petition in this case. Kindly extend the intermatter.
In all these matters, wherever in.
First time for 1 week, my lord.
Not possible. 1 week, how is it possible? Yes.
For order.
Your ladyship, serial number 32.
30?
32, your ladyship.
Huh.
I'm for the petitioner. Mr. Arun is unwell. May I request if the matter be taken up on 13th of February, subject to the convenience of the court, your ladyship.
After 2 weeks.
Grateful, your ladyship. Ladyship, serial number 33, I am for the respondent.
Hmm.
Parties have executed their memorandum of sale. They are executing a gift deed today as per the terms. This may be taken up on 13th, subject to the convenience, your ladyship.
2 weeks.
Much obliged.
For being spoken to, cell number 1,
Millard.
Kailash Shankar,
Serial number 23 ಅಲ್ಲಿ entry ಮಾಡಿದೆ ಸ್ವಾಮಿ extend ಆಗುತ್ತೆ.
It will be extended. Yes.
Grateful Millard.
Yes. What are this are being spoken to? Hmm. Huh? It is till what is the date? How much is taken? Then how can it be? It is still. Huh? Where is the table? From 50 to 60, how much? 40 to 50, 25. 40 to 49. 50 to 60, it's 10%. You are already 50. So how can it be 25%? But when you're reappreciating, we can't do the mistake again. It is submitted that. 5%. How can 5% be interest taken? Who did this? It is submitted that. In all the cases, it is 6%. How come for the first time it is invented? I don't know. The matter is placed before this court. The caption for being spoken to. Then counsel submits that the claimant is 50 years old. Future prospects are taken at 25% or 10%. The tribunal has taken 25%, and the interest is at and the interest that is given is 5%. It should have been 6%. As far as the future prospects are concerned, for the age from 50 to 60, it is 10%. 10%, and the court had rightly taken, and this court, while be appreciating the compensation, cannot commit the same mistake as done by the tribunal. Then coming to the interest, the same is modified as 6%, and the corrected copy shall be uploaded.
Cell number 2. Mr. Vanman
Respondent in this case, my lords.
Yes.
Let's, they have filed a petition challenging the semis orders which has been passed in trial court, my lords, where the said maintenance has been allotted for 4,000 rupees, which is the nominal amount for the.
Switch on the mic. Please use the mic.
My lords, they have challenged the orders which has been passed by the trial court, my lords, by the family court.
What is the interim order in this?
My lords, it's an amount which has been granted for 4,000 rupees.
The
as per
tribunal has
maintenance.
awarded the maintenance, and this court is not inclined to remand the matter. Whatever the documents, and the petition line shall be placed before this court. List this matter. So there is no interim order in this.
No, my lords.
Yes. Delete from the caption dismissal. List this matter before the court having roster. Yes.
Cell number 3. For orders matter, cell number 3.
Lordship.
Non-functioning of cover.
Yes.
PF file ಆಗಿದೆ sir.
The process is not vague.
File ಮಾಡಿದೆ sir.
It is submitted that the needful is done. List after service of notice. Yes, 4.
Cell number 4. We can Narayan Sharma.
I'm appearing for the petitioner.
Yes.
A week's time may be granted, I will pay.
A week's time.
Much obliged.
Needful shall be done in a week, or else default order
Yes,
in
number
4.
5.
Yes, 5.
Take control.
On behalf of the petitioner, my lords.
Yes.
My lord, in
Now-
fact, this was, my lords, my instructions are, my lords,
Yes.
I am at the sympathetic jurisdiction of this court.
Yes.
I can make that submission very openly.
But in fact,
Now, I'll just make my submissions probably that will adhere to the benefit of my learned friend also.
Yes.
Now, my lords, pursuant to my lords, the direction that was given by this court, where my lords, we made a submission that there could be a settlement in this matter. We are, my lords, willing to pay the amount, my lords. The factum of we borrowing loan is not disputed. The factum of we having not repaid the loan on time is also not
What is
disputed.
outstanding as on today?
Outstanding, my lords,
5.28 crores. my lord.
5.28 crores.
no, the loan amount, my lords, I'll just, my lords, indicate the figures. The total sanctioned loan amount, my lords, was 3 crore and 40 lakhs. Out of which, my lords, 1 crore and 98 lakhs 20,000 has been repaid.
Out of which, how much is repaid?
1 crore 98 lakhs, almost more than 50%, my lords, has been repaid.
When have you borrowed it?
My lords, this was borrowed in 2015. Lords, more than 50% has been repaid. I am also not, my lords, assisting your lordships that I am not going to repay this loan. Certainly, my lords, there is an obligation on my part. Now, my lords, the dispute arose where one of the terms of the loan, my lords, was that floating rate of interest, my lords, would be charged insofar as the computation of interest. RBI floating rate of interest, lordships are aware. My lords, as against the condition which was stipulated that floating rate of interest would be charged, what the bank would do is, my lords, ask me to pay a fixed interest at the rate of 11.8%. That is where, my lords, the entire dispute, my lords, opened. Now, my lords, for a moment, my lords, let me not trouble your lordships with
No,
the
when
numbers.
when these kind of disputes arose,
Please.
what is the remedy to a
I
borrower?
go down, my lords, which is why
No, that's what I'm saying. There will be a bank's ombudsman or someone who is there who will address these issues of the borrower.
my lords, what compelled me to rush to this honorable court was my place of dwelling, where I stay along with my family members, is the property, my lords, which is put in security towards
When
this
was
loan.
your loan declared as NPA?
My lords,
On 1/12/2023.
1/12/2023. When did you bring to their notice about this floating interest and all?
That
No,
has
the
not
legal-
been brought into notice. My lord, that is
12,
not been disputed.
When the 13 notice is issued.
please, my lords, I would issue a legal notice. May I pursue your lordships to kindly turn to page number 40, my lords.
Page, dated
12/12/2023 itself.
12/12.
2023 itself. I would issue a legal notice calling upon them that, look, you had told me floating rate of interest.
What was the response to
No
that?
response at all.
Then when 13 notice is issued, did you say so?
My lords,
That would be that is a juncture where you will get the reply from them.
please, my lords.
What is the present stage?
My lords,
My lord,
thereafter, my lords,
Present stage of the proceedings.
Section 14 order has been passed. In fact, when the Section 14 proceedings was pending,
The petitioner approached this court and he obtained an interim order to deposit within 4 weeks about 50 lakhs. That is not complied.
No.
Deposit happened 6th week 10 lakhs. Then
Yes.
Lord, the first installment, they
Interim
as
order,
10
my lords,
lakhs.
has been complied.
Let me hear.
No,
Yes.
Lord, interim order was passed on 31/7/2024, granting 4 weeks time to comply with that, to deposit 50 lakhs. The first deposit of 10 lakhs happened, my lord, on 3/9/2024. That is much later,
Oh, interim order was when?
31/7/24.
31/7/2024.
Please.
Direction was to pay within 4 weeks.
4 weeks, 50 lakhs to be
50 lakhs.
deposited.
When was
So,
it paid?
First deposit happened of 10 lakhs on 3/9/2024.
3/9/2024. Yes.
The second deposit, my lord, happened on 8/10/2020.
8,
No,
how
14,
much?
14/10/2024 of 40 lakhs.
14, 10, 40 lakhs.
So in between, my lord, on 8th of October, the magistrate proceeded and passed order on section 14.
8th of October.
8th of October. 2 days later, they have deposited the remaining 40 lakhs. But since there was no interim order, magistrate went ahead and passed the order. Subsequent to that, petitioner files one more application, Lord, seeking direction for the setting aside of this particular order of the magistrate. So that is where it stands.
May I make the submission, my lords? My lords, your lordship posed a question to me as to what was my stand, my lords. No sooner I received a notice under section 13. My lords, may I persuade the lordships to kindly turn to, my lords, page number
Yes.
52, my lords, of my paper book. This is a communication which I would issue on 19th of March 2024, expressing my willingness to pay, requesting them, my lords, for an OTS of 2.25 crores. This communication was not acted upon.
Not acted up.
There is absolutely no binding obligation on them to act upon, my lords. I bow down to that proposition. There's no difficulty. Now, my lords, during the pendency of this petition also, my instructions are, my lords, I'm making this submission, my lords, upon instructions from the petitioner. They have now proposed, my lords, an OTS of 3 crores and 52 lakhs, for which, my lords, the bank has made an ask, my lords, of 3 crore 87 lakhs. So, my lords, the only differential window is, my lords, for about 30 lakhs. My only request your lordships could consider, my lords, if your lordships could kindly consider is, lords, let, my lords, the bank take a stand. The lordships may give me, my lords, 2 days time, I shall make an application, my lords, setting out, my lords,
They have
the
already
Okay,
taken
but
a stand by
same-
saying that it is not acceptable to them.
That same submission was made on even 5th of December. On that day, the same, the due was, in fact, the official was also present. He's present today. At 5.28 crores is what the bank is proposing. Anything lesser than they're not acceptable to them.
No, 3.52 or 5.
No, my
5.28.
instructions are,
Because they has made the same submission of making
No,
payment
he's
over
saying
3.
that what is the bank's proposal?
well, my instructions are that the bank has proposed 3 crores and 87 lakhs.
That's
And I
wrong.
am willing to pay 3 crores and 52 lakhs.
No, they say that it is 5 crores.
5.28.
This is the email communication, my lords, which I have been given.
Are you sure about
Yes, in fact,
5.28?
I have the officer present here.
Ask him, is it 5.28 or 3.
5.28 crores.
I just pass on this email communication, my lords.
Give him that.
No, it's only, it is the proposal from their side which has not been accepted.
No. It is a communication from you to the petitioner.
No, my lord, it is
Email
from him.
exchanges.
No, correct. He has proposed to make the payment as through 3.52.
After meeting
That has
the
not
bank
been
official.
subject, that has not been accepted. There is no response to this email. This is
No,
email from the
Before
petitioner.
that, where from you get this 3.87?
My lords, there were discussions, my lords, which the petitioner had with the bank
In
official.
that regard, there is no email that they are ready
For which,
for.
my lords, the petitioner would issue an email saying that, look, you have told me 5.87, I am willing to pay you, I'm sorry, you have told me it is 3.87, I am willing to pay you 3.52.
They know what you want to, your this thing is 5.28.
Please.
Yes, please come. Agreed with the presented petition is filed. Seeking the following prayer. Land Council, the facts of the case are petitioner has obtained a loan from the respondent bank. Where is it? And he has repaid an amount of rupees 1 crore 98 lakhs 20,508. It is a grievance of the petitioner that, contrary to the terms set out in the sanction letter and loan agreement, the respondent institution began charging interest at fixed rate of 11.4 while willfully omitting their
11.8, my lord, I'm sorry.
11.4%. While willfully omitting their obligation of charging interest on the floating rates. In this regard, the petitioner has issued a legal notice dated 12/12/2003 to the respondents, calling upon them, requesting them to rework the outstanding liability of the petitioner under the agreement. Despite the same, the respondent institution continued to conduct itself without even considering the legal notice. It is the case that the respondent institution assured the petitioner the request made by the petitioner would be considered. To the surprise of the petitioner, in the first week of January 2024, the petitioner received a notice under Section 13(2) of the Securitization Act. You didn't give a reply to this?
Well, the
Then
reply was in the
response to
form of
that,
proposal to
the
consider
petitioner
OTS.
went to has approached the respondent institution seeking a one-time settlement,
Dated 19th of March 24.
19th of March 2024. Then after that, the respondent bank has initiated the proceedings under Section 13(4) and Section 14 of the Surface Act. At that time, the petitioner has come before this court. When the A coordinate bench of this court on 31/7/2021 has issued an interim order subject to the condition that the petitioner shall deposit 50 lakhs within 4 weeks from the date of order, failing which the respondent is at liberty to take physical possession of the subject property in accordance with law. Land Council submits that in fact they've given a proposal to the bank for a one-time settlement of an amount of rupees 3 crore 52 lakhs, but they're insisting on 3 crore 87 lakhs. It is submitted that if that he'll go before the respondent and he will negotiate if a reasonable time is granted. Next para. Land Council appearing for the, who is the respondent?
Lord, L&T Finance.
The respondent, the Land Council appearing for the respondent submits that it was never a proposal from the respondent and they have never accepted for 3.87. Their proposal for one-time settlement is 5.28 crores. It is submitted that when an interim order was passed on 31/7/2024, the court has granted 4 weeks time, but the petitioner had not complied with the order within 4 weeks. In fact, an amount of rupees 10 lakhs was paid on 3/9/2024. Another amount of 40 lakhs was paid on 14/10/2024. As the petitioner has not complied with the interim order, the respondent bank proceeded with the section 14 proceedings and an order was passed by the magistrate on 8th October 2024. It is submitted that the petitioner has not issued any reply to the notice under section 13(2). It is also submitted that the petitioner, with regard to this floating interest, should have availed the appropriate remedy available to him. Land Council submits that there are no grounds to interfere with the order that is passed under section 14 of the Surface Act. The bank has taken this step as per in strict compliance with the provisions of the Surface Act. Next para. Having heard the counsels on either side, Perusa Mitchell on record. The entire grievance of the petitioner appears to be that instead of charging the floating interest, the bank has charged a fixed interest of 11.4%. If that is a grievance of the petitioner, when he was aware of this much before the account is declared as NPA, he should have availed the appropriate remedy. That the bank, contrary to the terms and conditions of the loan agreement, is charging the interest. But for the reasons best known to the petitioner, he has not taken any steps. However, the account was declared as NPA on 1/12/2023. It is the case of the petitioner that he has issued a notice on 12/12/2023. Thereafter, the surface proceedings were initiated. Even at 13/2 notice, after receiving the 13/2 notice, even at that level, the petitioner has not approached the bank, has not given his reply with regard to this, which will compel the respondent bank to respond to the notice, to respond to the reply of the petitioner in the light of the above facts and circumstances. This court is of the view that this is not the case where the court has to exercise the jurisdiction under 226 of the Constitution of India. Hence, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies, if any, as per law.
May I make one request, if your lordships can consider, my lord? Would my lords kindly observe that the observations in this order is confined
On the
only to this.
observations in this order,
Tomorrow they should not contain any other petition.
the observations made in the order are only for the purpose of deciding this application. The same shall not be construed as an expression of this court.
I'm so deeply obliged.
Chair
Obliged,
number
madam.
6, M.A. Rajendra, for petitioner, Prasanna R. Raju.
Your Lordship, I am the petitioner. I am the petitioner here.
Yes. Yes.
When I challenge the auction sale notice before DRT, auction sale notice is 2/11/2023. Challenging the auction scheduled to be held on 23/11/2023,
Yes.
which is in page number 59. Its order sheet is mentioned. Page number 59 order passed by the DRT in my IR number. When I challenge the auction sale notice dated 2/11/2023,
Now,
challenging the
before going to that, what is a prayer in the present writ petition?
yeah
Set
now
aside the impute order dated 21/4/2022,
yes
passed to the presiding officer so and so in IA number, in
yes
SA number.
yes.
Yes.
This the Honorable Debt Recovery Tribunal, though allowed my impleading application to implead the auction purchaser, naturally my prayer which I sought at the time of challenging the auction sale notice become rendered infectious. That is the reason I have filed my amended application challenging, stating that the auction purchaser when is impleaded, then the consequentially the relief which I should sought for is to set aside the entire auction proceeding and sale certificate. But that aspect, that amendment application, the DRT did not consider, is rejected. Against that, when I approached this honorable court, because, the IA could not able to reach before this honorable court. In the meantime, the debt recovery passed the final order. So when it's passed the final order, what challenge before your lordship in this writ petition has rendered infectious. But however, it is having the bearings on my another writ petition which I have filed, challenging the final order, which is in WP number 35299/2025, is pending.
Why should you come before this court instead of going to DRAT?
No, here only on IA I approached before your lordship. IA stating that amendment is required. It is necessary. When you
No,
allowed
on that
application,
on that IA, you can't go to DRAT.
IA also we can go to DRT, but pending adjudication before DRT. Then there was a time was there. That is the immediate on question of law. I approached the honorable court to set aside the order passed by the DRT in so far as in IA number 713, because when you allowed my impleading application, naturally my relief
No,
also.
that is not such a great question of law, the which DRAT cannot adjudicate, and
No,
that only this court will understand.
No,
and
because
decide.
no, my submission, my lad, 75% has to be deposited within 3 months. Earlier it was 15 days. After amendment 2016, 3 months was the period to deposit 75%. That all the auction purchase has not paid. After expiry period of 75.
Please go to the DRAT.
No,
Now
my
that the
submission,
final order has been passed,
my final order has been passed. Final
So
order,
that because that order has culminated into the
Yes.
main order.
Main order.
Both the orders questioned before the DRAT.
the order of the DRT.
Your Lordship, my humble
The,
the property has been sold much below the market value. my lad.
maybe the present writ petition is filed seeking the following prayer.
This prayer has become infectious now.
Yes, it is submitted by the land council, both by the land council, the petitioner, and the respondent, that essay number 287 of 2023 is disposed of by order dated 31st October 2025. Hence, this interim order has culminated with the final order. Hence, nothing survives for consideration in this petition. Accordingly, dismissed as instructed.
Obliged.
Chair number 7, Suman Naganan.
My lords, I may be
G.K.
permitted to withdraw the petition, my lords.
Yes, take that. With liberty for what?
My lords, what has happened is that this petition was filed with a lot of errors. So therefore, we filed a memo to withdraw this, my lords, but the file was misplaced. So therefore, it was never listed before this court. In the meantime, because sale certificate was being issued, I filed a fresh petition undertaking that I'll withdraw this petition, my lords. So it had come up before court on the last occasion, wherein I had made the submission and the honorable court had permitted me to withdraw this petition, my lords. So therefore, I'm withdrawing it.
The writ petition is, the memo is filed seeking to withdraw the petition with the liberty to avail the appropriate remedy. Accordingly, dismissed memo is taken on record, dismissed as withdrawn with the liberty to avail the appropriate remedies available to the petition. Hmm. Hmm. Oh, it's a part third. Let it be listed, yes. Instead of saying post before the appropriate court, I said. You should have said part third also. Ah, yes. So let it be after 2 weeks. Yes.
Hearing on interlocutory application, serial number 8. Tejasvi for petitioner.
For petitioner, Lord, this is the case where, though there is a valid insurance policy, my Lord, that the respondent insurance company, my Lord, they have misled this court. And they have.
Where were you then?
My Lord, the notice was not served on me, my Lord.
Let's see. Please check whether the notice is served. Where is that file? The original file, the MFA? Whether the notice, which respondent you were in MFA?
My Lord, I am a respondent number 4, my Lord. Yes, ma'am.
The file shall be put up along with so and so tomorrow. Tomorrow. Yes.
Serial number 9. Sunil S. Sridhar AG for respondent.
Correction of the order dated 29/7/2024. No representation on behalf of the petitioner. List this matter for dismissal tomorrow.
Serial number 10. Suman Naganan for
My lords,
petitioner.
in this matter, the petitioner is the bank who wants to proceed with surface proceedings, my lords.
You're representing the bank.
Please, my lords.
What is the relief that is sought in the
I
writ?
sought for a mandamus for respondent number 1 and 2 to clear the cars that are kept in the
Direction
mortgage property.
to remove the seized vehicle in the schedule. Who is respondent number 2?
State of Karnataka and Assistant Commissioner, my lords. The mortgage property, there are cars in the mortgage property, my lords. There's buts proceedings pending against respondent numbers 3 to 6, because of which the cars that were kept over there have been
No,
seized.
how come a writ petition for this?
My lords, because state is not taking any action to remove the cars. It has been seized by them. My lords, there was a mortgage deed between the petitioner and respondent number 3, my lords. So respondent number 6 was the subtenant of respondent number 3 to 6 who had mortgaged the property to petitioner. There are buts proceedings, proceedings under the Buds Act, my lords, because they defaulted and they have cheated some people. So therefore, buds proceeding against respondent number 6. Respondent number 6 had kept over 150 cars in the scheduled property. So we wrote them a representation saying, because of the buds proceedings, cars belong to you, that is the state government. So kindly clear it, because I have to proceed and sell the property under the Surface Act. However, they have not taken any action, my lords, till now.
So therefore, under the Surface Act, what is the remedy available to you?
There is no remedy available.
Why
my
not?
lords. Because the cars are under them, my lords.
So maybe the property belongs to you.
Please.
You can take the vacant portion of the property.
I have already taken, my lords. There's a section 14 order also. But because the cars are in place, which belongs to them, there's an order of the magistrate also at page number 88, which says that they are to vacate the property by taking all the cars. There's a mahazard drawn also. Despite that, they have not removed the property.
So if there is an order of the magistrate, if they're not doing what is to be done?
That's a filed.
Again, the High Court will pass another order.
Directing them to remove it, my lords.
Yes.
That seek instruction, file a written statement objection of this.
My lords,
Tomorrow.
Today they received the file.
Tomorrow.
Grateful, my lords.
Council, what is that? AGA takes notice for the.
Tomorrow better, sorry, Monday happen. Tomorrow, Saturday, Monday happen. I got some other.
It's a very, one telephonic instruction should work. Why should the bank be facing all this problem? You have to get instructions. AGA takes notice.
Kindly have it on Monday.
And shall get instructions by tomorrow. Why when there is an order of the magistrate, why the state is not acting on that? Yes.
Grateful, my
Serial number
lords.
for admission, serial number 11. Prithvi Vadeyar for petitioner. Gauda.
Your Lordships, before making submission on merits, may I request your Lordships kindly turn to the order dated 6/11/2025. It requires some correction. It is some
Yes.
mistake.
Where is
A
the
delay
order?
was 6/11/2025, your Lordships. 11/2025. Delay was condoned. Thereafter,
1 minute, let me look at it. Yes, Lem, yes. IA is filed to condone the delay of in filing the appeal.
for the reason,
Condone.
IA number 1 of 2025 is allowed and delay of 119 days in filing the appeal is condoned. However, the claimant will not be entitled for interest in case of enhancement of compensation of the for the said period. That has to be removed because this is a review petition against an injunction order, not a claim petition, your Lordship.
Oh.
That portion has to be removed.
The order dated 6/11/2025 is modified. And the portion, however, the claimant will not be entitled for interest in the case of enhancement of the compensation for the said period shall be deleted.
Now, your Lordships, kindly turn to the order for admission.
Yes.
Page number 10, the order.
Page number?
10, your Lordship's order. This is an appeal which was preferred by the plaintiff. Plaintiff has originally filed 2 applications before the trial court, IA number 10 and IA number 11. And both those applications were dismissed by the trial court. Agreed by that, he had approached your Lordships. While filing against that order, the defendant number 1 alone has filed caveat and he has entered appearance, your Lordship. The petitioners herein were defendant number 3, that is the firm and its directors. We were also party in this appeal, but no notice was ordered in this
So
appeal.
what is that IA?
IA, that is
The
one, IA number 10 is for not to put up construction and IA number 11 was not to alienate the shoot schedule properties. IA number 10 has become.
What is the relationship between D1 and D2?
D1 and D2 are father and son. I am D3. I am JDA. I'm Joint Development Agreement holder. I had constructed the building in his property to which the defendant number 1 and 2 that site belongs. And after construction, there was a partition with regard to 4 apartments have fallen to the share of.
Give that file.
Order sheet also I have produced, your Lordship.
Give the file.
Order sheet at page 25 in MFA order sheet. One minute. On 31/8/2024, your Lordships, in that order sheet of MFA,
Yes, what do you say?
he appears for defendant number 1.
I am applying for defendant number 1 and 2 in this.
Where is the plaintiff?
Plaintiff he has served. He had appeared last time, but today.
Sharath S. Gowda.
Sharath S.
Where is he? Sharath S. Gowda.
My lords, senior is on his legs, my lords. I request for a passover, my lords.
Passover is not possible. I am in a larger bench in the afternoon.
My
This is
lord,
matter tomorrow.
Great.
Yes.
Cell number 12.
I for the petitioner, my lord. This is the case, my lord. The petitioner here is challenging the Annexure J impugned order passed by the Honorable DRT 2, dismissing the IA 222 of 4 of 23. The reason assigned by the DRT 2, my lord, that the defendant herein IA has not prosecuted the case diligently and in spite of sufficient time given by the tribunal, my lord.
Why did you come before this court is the first question.
Please, supervisory jurisdiction, my lord, because
So,
they did. Please, my lord.
DRT, again, it's an order of DRT. It is only DRT. You have to go. If you're coming to the High Court, what are the exceptional reasons why this court shall entertain? First, you should tell the court, not supervisory jurisdiction.
Please, my lord, because there was an error.
That is what, if there is an error only, you will file an appeal.
Yes,
Please
my
come.
lord.
Agreed with our order passed. The present petition is filed. Seeing the following prayer.
Short date may be.
The petition has approached this court, agreed with the order passed by the Debt Recovery Tribunal 2, in OA number 63 of 2022, dated 9/1/2025. If the petition is aggrieved by any of the orders that are passed by the DRT, the remedy available to the petitioner is not before this court, but before the DRAT. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in accordance with law.
13. M.A. Rajendra for petitioner. K.P. Monish Kumar.
Same for the respondent in this case.
Yes.
There is an inordinate delay, please, my lords, of even filing the securitization application, my lords, before the DRT. Now, there is no provision, please, my lords, under the DRT Act, please, my lords, or on the SFSC to condone, my lords, the delay, based on which, please, my lords, the limitation aspect was considered and the application was dismissed and the ensuing essay was also dismissed. Over which, my lords, they have come here. They might, my lords, have to file an appeal before the DRAT. Instead of approaching the DRAT, they have come here, please, my lords, in humble submission.
Yes, Mr. Rajendra.
Yes, my lord. Under section 14 of the Act, the borrowers or mortgage or guarantors are not made as a parties. Only remedy is we have to challenge the 13(4), the possession notice. When the bank came and issued the vacating notice, which is page number 49, Annexure D, 28/8/2024, that is the date when they gave the, sorry, man, the vacating notice is also there, 28.
When was the account declared as NPA?
No, here question of
26/10/2022. 26/10/2022.
And based on this vacating notice,
26/10/2022. When was the 13(2) notice?
The 13(2) notice was issued.
The 13(2) is issued
31/10/2022, man. That can be seen in the page number 90, my possession notice.
13(4). When was the 13(4) notice issued?
13(4) notice issued on 18/1/2023.
Order under 14.
Yes, my lord. This order, which is page number 48.
Dated?
29/3. 29/3/2023, page number 45. When the bank,
have you received the notice? Have you received the notice under 13(2) and 13(4)?
Yes, sir. 13 to 13(4) we have received.
So what did you do after 13(2) notice and 13?
We have challenged only section 14 order. Section 14 order passed by the magistrate, wherein after getting a receipt of the vacating notice, immediately we approach the Honorable DRT.
You are not aggrieved by any of the measures under 13(2) and 13(4).
No, 13(4) possession notice, because sometimes the bank has failed to serve the copy to all the applicants hearing. So that is the reason when the 14 was served on us, the vacating notice, immediately we rushed to the Honorable Court to obtain the certified copy. That only we have challenged. Under section 14 only we have challenged before DRT, stating that there is a delay of 476 days. Since DRT cannot condone the delay under section 5 of the Limitation Act.
What I want to know is,
yes, my lord.
When a notice is issued under 13(2), did you give a reply?
No, my lord.
When you received a notice under 13(4), what did you do?
That we are not challenged, my lordship.
So you are not, you are just keeping quiet, and so now you say that till the vacating notice is issued, you are not aware of the proceedings.
No, we are aware of the proceeding, but under section 14 only, that order only I have challenged before the DRT. Because under section 14 also.
Yes. And now the second question is, why should this court entertain this this writ petition?
Because delay cannot be condoned either by DRT or DRAT. From the date of knowledge of the vacating notice, immediately
No, let's come to the order. We will read the order.
Yes, my lord.
Yes.
Kindly page the last page number 27. Operative portion of the order. Page number 27. Hope your lordship got it, man. Para number 18. Only on delay it has been dismissed.
The petitioner applicant in paragraph number 4 of the essay under the head limitation in an unclear manner have stated that the application has been filed within the period of limitation from the date of issuance of the vacate notice. The averments read follows. Read paragraph 6.
Yes, my lord. The petition applicant in paragraph number 4 essay under the head limitation in an unclear manner have stated that the application has been filed within the period of limitation from the date of issuance of vacating notice. The averments read as follows. The applicant, though, had earlier submitted the impugned order passed by the Honorable Principal Civil Judge so and so in essay number so when they have challenged the auction scheduled to be held on based on the auction sale notice. The said application was disposed on the ground that it has rendered infectious. The applicants herein, when they have intent to settle their account under OTA scheme of the bank, and the bank had assured all the measures will be withdrawn subject to settling the account under OTA scheme, which though the applicants agreed, but surprisingly our respondent bank never issued any notice.
Pausing here for a minute.
Yes,
27/7/2023 auction notice was issued.
Yes.
When
That
the
is-
auction notice was issued?
That is separate
Before
also.
14? No,
That is
before
separate.
14 or after 14?
After 14 only, they have 11/7/2023. This is auction sale notice.
Is issued. So that means you are aware of the auction notice about section 14 proceedings by 27/7/2023 when the auction is conducted.
No, they have to. The order has to be. The order copy has to be furnished to me. Where I'm not a party to the proceedings at all. Under section 40, we never the party.
Here, auction
13/4, yes.
proceedings were questioned by you.
Yes.
That is, auction was when 27/7/2023 auction was questioned by you. If they have conducted the auction on 27/7/2023, by that time already section 14 order is passed. When you have questioned it, it is by when you are questioning this order, that is with the legal help is there for you to the party. He is aware of a section 14 order by 27/7/2023 itself. When did you file the essay?
Yes, sir. On
Essay
2/9,
is when?
on 2/9/2024, 2/9/2024, page number 66.
So how many days from 27/7/2023 to 29/2024?
That's 426 days. They have written.
It is almost 1 year, 2 months.
Yeah, 426 days delay.
Yes, please come.
476 days.
Yes. Anything you want to submit more?
No, your lordship. Because there is a delay is 476 days. The delay is there.
The
With regard to
physical
position.
The present petition is filed seeking the following prayer. The petitioner has availed the credit facility from an amount of rupees 15 lakhs from the bank, which was later enhanced to 3 crores, and also availed UGECL loan of rupees 30 lakhs, totaling to rupees 3 crore 30 lakhs. In view of the COVID-19, he could not service a loan account. The respondents have classified the account as non-performing asset on 26/10/2022. And it is stated that the respondent bank alleged to have issued the notice, demand notice under section 13(2) of the Surface Act on 31st October 2022, followed by the possession notice dated 18 January 2023. Then the order under section 14 of the Surface Act was passed by the Principal Senior Civil Judge and CJM Mandya in criminal miscellaneous number 71 of 2023, dated 29th March 2023. Thereafter, the bank has issued a vacating notice which was received by the petitioner on 28/8/2024, and immediately he obtained the certified copy of the order passed by the CJM Court Mandya and approached the DRT by filing SN number 449 of 2024. In the process, a delay of 476 days occurred. The DRT, by order impugned, had dismissed the IA that is filed by the petitioner, seeking to condone the delay of
70 days.
76 days. Page number 27.
470 days.
76, my lord. Page number 27 is there. Last paragraph.
Even in the application also, it shows 470.
But in the order sheet, para number 18, page number 27, 470 they have mentioned.
I think different days are mentioned in different 476 days delay. What did you write? To condone the delay 476 days that came to be dismissed by the DRT. While dismissing the same, the tribunal has observed that the tribunal is required to weigh the explanations offered by the petitioner applicants and the acceptability of the same. The delay in the case reflects the inactivity and the inaction on the part of the applicant. The law does not permit one to sleep and to seek one's reliefs as and when one desires. When the parties claiming to be aggrieved by the measures taken under section 13(4) of the Act, the secured creditors approach the tribunal at their own leisure and pleasure. The law does not permit a really aggrieved person to sleep and approach a legal forum as he desires. If he does so, it is at his risk and responsibility. The delay cannot be condoned, keeping in mind the avowed object of the Act. The tribunal has felt that the petitioner has not shown due diligence in filing the essay at the right time, and the same cannot be condoned in the absence of any valid explanation. Accordingly, the tribunal had dismissed the IA that is filed to condone the delay of 476 days. Learned counsel appearing for the petitioner submits that once the vacating notice is issued, immediately they have approached the respondent. They have approached the court. They have obtained a certified copy of the same, and they have filed the essay. It is submitted that till the vacating notice is not there, the petitioner is not aware of the proceedings under section 14, as there is no participation of the borrower in the section 14 proceedings. It is submitted that the court, without considering the reasons that are stated in a mechanical manner, has dismissed the application considering unless the delay is condoned, the petitioner would be put to great hardship. Next parallel, counsel were appearing for the respondent submits that as the petitioner has failed to give the reasons for the said delay, court had rightly dismissed the application, dismissed the IA that is filed to condone the delay. It is submitted that when an order is passed by the DRT, the remedy available to the petitioner is to go before the DRAT, but he cannot come before this court. It is submitted that there is no infirmity, there are no infirmities with the order passed by the tribunal, and no interference is called for. In response to that, land counsel for the petition submits that though he has a remedy to go before the DRAT, he has come before this court on a question of law as whether the delay can be the delay cannot be condoned by the DRAT. It can only that said question of law can only be decided by this court. Next para. Having heard the counsels on either side, peruse the material on record. The petitioner has approached the DRT with a delay of 476 days. According to him, when he has received a notice under section 13(4), immediately, when he has received a vacating notice, he has immediately obtained the necessary papers and rushed to the DRT. The admitted facts in this case are the NPA, the account was declared as NPA on 26/10/2022. A notice under section 13(2) of the Surface Act was issued on 31/10/2022. Possession notice was on 18/1, that is under 13(4), that is on 18/1/2023. An order was passed by the magistrate on 29/3/2023. It is also undisputed that when the bank, pursuant to the order under section 14, when they have issued an auction notification and the auction is scheduled to be held on 27/7/2023, the same was questioned by the petitioner. When the petitioner have questioned the said auction notice, which is scheduled to be held on 27/7/2023, by the time, it is a fact that unless the order under section 14 is passed, the auction will not be held by the bank. Petitioner is having a legal help when he has questioned the auction. Then it has to be construed that the petitioner had the notice of section 14 order as long as back on 27/7/2023, but the appeal is filed on 2/9/2024. That clearly shows that the petitioner was not diligent in pursuing the matter, and and he has not even stated the correct facts why the delay has occurred, and he tried to submit. It is argued that he came to know only about the 14 notice when a vacating notice is received, 14 order when a vacating notice is issued, and this court do not find any reasons to condone the delay. The tribunal has rightly considered and rightly passed an order. Accordingly, the petition is dismissed.
Bill number
So
14. M.A.
Yes.
Rajendra for petitioner, Venkat Ramana for respondent.
Yes.
Your Lordship, I am the petitioner hearing.
Mm.
Kindly say page number 17 of the final order, the common order.
Now, why you have decided to come to the High Court on every order that's filed with the DRT, not going to DRAT? Is it a special privilege to you to come here in every case?
No, Your Lordship, my humble submission is, division bench, one division bench says delay cannot be cut down. Another division bench says delay can be cut down. Recently, the Honorable High Court of Karnataka said that delay can be cut down. Madhya Pradesh said delay can be cut down. Supreme Court matter is pending, delay cannot be cut down by DRT. Suppose, assuming for a while, even if I complete your DRAT.
Let us see what is the order.
Here, Lordship. Page number 17. Page number 17. I'm simplifying my argument, my lord. Kindly see the three application, they have passed the common orders.
Yes.
Hope your lordship got it, page number 17.
Where is the operative, the portion of the order?
No, only 1 second, I will convince the court. One order sheet, the cost cycle. Kindly see the cost cycle. Securitization application 434, that is possession notice. Securitization application 110, 2017. So both got dismissed. I did not challenge it. Section 13.4 measure I have not challenged. Section 14 I have not challenged. Auction I have challenged. Securitization 136, 2017. It is allowed in my favor. Sale is set aside. Entire auction proceedings set aside. Securitization application 136, 2017. The DRT, while passing the common order, states that the measures initially the bank, in so far as conducting the auction, is set aside. When such being the case, what will happen to the position already been delivered to the auction purchaser? Section 17.3 clearly says, when the measures initiated by the bank is set aside, then
Where is the respondent counsel who appear?
How to get back the position? That is a question of law. Otherwise, you should have, instead of common order, you should have filed the separate
No
order.
representation on behalf of the respondents. This matter next week.
Cell number 15.
That is the reason I am approaching before the Honorable High Court of Karnataka about
Yes,
this.
let the counsel is not here.
15
Okay.
We'll hear them both of you at a time.
Please, my
lord. Just 1 week time, my lord. This case may instructed that my lord, he has approved bank settlement, my lord.
Huh?
Just 1 week time, my lord.
Why?
My client instructed me that my lord, he has approached the bank for settlement, my lord. I'll have it in next week, my lord. Any date may be fixed, my lord.
Petition. This matter has come up, is coming up from 39/2025. First, let us see what you have questioned.
Yes, I am challenging the
Yes.
notice issued by the bank, my lord, for taking physical possession of the scheduled property, my lord. And also,
Why we have to, how can you question that notice?
this case, my lord, I have already filed, my lord.
Notice under 13.4.
No, after completion of CMIS order, DRT SA order, we have issued 7 days notice to get vacated.
How can that be questioned before this court?
SA also dismissed. CMIS also.
If SA is dismissed, what you are supposed to do?
Dismissed for non-prosecution, my lord. Now I have filed miscellaneous application for recalling that order, my lord. That is pending, my lord.
That you should pursue. You can't have a. How can when they have become final? How can you question a final petition here?
Please, my lord, I will pursue that petition for recalling, my lord,
Yes.
before DRT, my lord.
Represented petition is filed seeking the following prayer. Learned counsel appearing for the respondent submits that already the essay that is filed by the petitioner is dismissed. Thereafter, they have issued this notice. Notice to vacate the premises. It is submitted that without questioning the order that is passed by the DRT in the essay, the petitioner cannot come before this court questioning a notice which is consequent to the dismissal of the essay. It is submitted, learned counsel appearing for the respondent submits that he has filed a miscellaneous petition before the DRT. If the petitioner has filed a miscellaneous petition before the DRT, the petitioner has to pursue the said remedy and he cannot come before the court by filing, cannot come before the court questioning the notice that is issued by the bank. This court do not find any reasons to interfere. Accordingly, this court is passing the following order. The petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies. Yes, next.
Cell number 16. Yeah, Mahesh Chaudhary for petitioner.
Petitioner, your lordship, we have challenged the possession order passed by the learned civil judge, your lordship. The due amount is of 3,16,000, your lordship.
How much?
3,16,000. It's my sole residential building, your lordship. I'm ready to pay 50% in 1 week, your lordship.
Remaining 50%?
4 weeks time may be granted, your lordship. I'm a farmer by profession.
Very small amount.
My lord, I will permit you to say.
We will ask them to file an undertaking affidavit by tomorrow.
One submission, my lord. If my lord's permit, I will make a submission in this case. My lord, the loan has been, tenure has been over in this matter. From past 3 years, not even a single NPA has been paid in this matter. We have taken the position. 13-2 notice has been issued, 13-4 has been issued, all the notices were served
No,
up.
what we do is keep the position with you.
Yes, my lord.
Keep the possession with you.
It is not
Now-
3,69,000.
Huh?
It is not 3 lakhs what he is contending.
Hmm.
My lord, as on date, my lord, as far as my instruction is concerned, it is more than 5 lakhs, the outstanding due. If they approach us, the bank will consider the request. My lord,
Bank settlement will be there.
we will give the small waiver to that effect also.
Yes, approach them.
It may be taken up next week, your lordship.
Yes, list this matter next week. Land counsel appearing for the petitioner submits that the outstanding is 3.16.
Please, your
According to the land counsel for the bank, the outstanding is 5 lakhs.
More than 5.
More than 5 lakhs.
More.
It is submitted that from the last 3 years, no amounts are paid. Petitioner has not approached the bank. The petitioner, if the petitioner wants to approach the bank, he can approach the bank and he can negotiate with the bank. List this matter next week.
Possession has been taken, my lord. That has been.
It is submitted that in his submissions,
That
position is already
taken on 10-10-2025.
10-10-2025. Yes.
Much.
Yes, next.
17, Abdul Jabbar for
17,
petitioner.
your lordship. I'm for the petitioner, your lordship. It's a very small issue, your lordship. I'm the sale auction purchaser, your lordship. When I approach to get my title deeds register, I'm informed by Karnataka Small Disputes Insurance Bank that the property never belonged to the borrower. Auction.
You're an auction purchaser.
Please, your lordship.
And now the bank says
The property never belonged to the original borrower.
And what about your money?
It's been taken, your lordship. Sale certificate has been issued to me. So I'm only seeking.
When was the sale certificate issued?
Please, your lordship. It's issued on 16/5/2025.
16/5/2025.
Your lordship.
Physical possession was it was never given.
No, your lordship.
Your lordship, what has happened is the property belongs to the KSSIDC, the respondent number 3, your lordship. So without, I don't know on what basis the Canara Bank has issued the sale certificate, conducted the auction purchase without taking my permission, your lordship.
I think we should conduct we should ask the Reserve Bank of India to conduct an inquiry into the affairs of the Canara Bank. Where is Ignesh Shetty? Ask him to come.
Your lordship, I may also
Let him come. Ask him to come.
I've also sought for some instructions to show
No
and
instructions.
documents
No,
also.
third respondent is a different aspect.
Yes, and their
No,
query is
why
also
does the
against
Canara
respondent.
Bank?
Yes.
No, don't they have any responsibility to look at the property, to have a due diligence should be done by them or not? How can they? Nobody will come forward for bank auctions if this is the way. This is not one case. I've seen several cases. No, Reserve Bank of India. Who appears for Reserve Bank of India?
We came to KSSIDC came to know about it only
No,
when
who
the
appears for
petitioner-
Reserve Bank of India?
check, your lordship.
It's a union. Union of India represents.
Please, your lordship. I have not made them a party though in my
It's
petition.
there. Reserve Bank of India is a party.
In my
Red petition. Give it.
17th serial number. No, your lordship.
Respondent
Yes.
before your lordship.
I'm apology, your lordship. Apology.
Yes.
Apology.
Who represents Reserve Bank of India? First, call Vignesh Shetty to come.
Please, ma'am.
Yes.
Pass over, your lordship.
No, now itself. Once he comes, I'll
Please,
call.
please.
Yes, next.
I may kindly be permitted, your lordship, by matter survey.
Yes, yes, you can go.
18 adjourned, cell number 19. Madhukar Deshpande for petitioner.
I have to respond in this case.
Milord, on 2/9/2025, after hearing all lengthy argument, your lordship had directed the petitioner to file her affidavit with pertaining to her working details, milord. So they have to supposed to
The
file that
respondent
till
has been
today they
submitted. The
haven't
wife
filed
is
it.
working in SAMS.
No, I am just making my submission since.
How can you make your submissions when he is a petitioner? You will get your turn.
Today he has not filed, milord. That is the reason I
That you
just
will
brought
get,
it.
that you will get your opportunity. What he wants to say, please listen. Yes. 2/9/2025. Land counsel for the respondent husband submits that the wife is working in Samsung Service Center, Ankita Service in Tumkur, and the said fact is suppressed. Land counsel of the petitioner wife submits that he'll get instructions in this regard, and the wife shall file an affidavit whether she is working or not, whereabouts and details of her income. Where is the affidavit? Affidavit.
Affidavit is-
At the time of filing of this petition, I was not working.
Then who filed the RPFC before this court? You filed. From when you started working? Did you say so before this court? I'm earning a salary of 13,000 per month. You don't even specify from when you are working. No, what is the difficulty in stating so in the affidavit?
May I make one submission, my lord, with your lordship permission?
1 minute.
Please.
Where is the document with regard to your service? No, then in that case, in your affidavit, you should have stated from when you're working. Why you have not stated? It goes against you. This affidavit, your difficulties, court will appreciate provided first you say the facts before the court. When you suppress the facts, but that's what we have to assume with this from 18 to now. What was the amount granted? On what ground it was not granted? What is the husband's income? What is the husband's
My
income?
lord, from last 12 years, my lord, I was driving the car, my lord. I was a driver. From last 3 years, since I'm not well, I'm not working. The kids are with me from last 12 years. I am the one who's taking their entire education. The elder son is doing the first year degree. The second son is doing the second year PUC. And they're with me, my lord. I am the one who's taking their nourishment, everything. I am the one who's doing. Not I'm being educated, and my qualification is 10th failed, my lord. So that's the reason I was doing a driving job of the 4-wheeler, my lord. Since because of my health issue, from last 3 years I'm not working. My family is taking care of my children's, my lord. And medical I can produce at all, my lord.
Have you filed your statement of assets and liabilities before the court?
This is the matter of 2014, my lord. At the time there was no direction of such, my lord.
Both the parties shall file their statement of assets and liabilities
Please,
before this court.
My
at the
lord,
next
my
date
one
of hearing.
submission, my lord. The document, the learned counsel of petitioner, what they have filed, document number 3, my lord. After your lordship direction, the date is 2/9, my lord. The document is dated is on 18/9/2025. After your lordship direction, the medical has produced. Moreover, my lord, this ground is never taken in the Simis petitioner, nor.
That is not the concern now.
Please, my lord.
Please place before the court from when she is working.
Please, my lord.
And also both of you file your statement of assets and
Please, ma'am.
liabilities. This is matter after 4 weeks. Yes, next.
My lord, 2 weeks, my lord, since it is a 18 matter. my
We will
lord.
see 4 weeks. By the time I'll be sitting in Bangalore.
Please,
Yes,
ma'am.
20. Written to him. File a better affidavit.
Cell number 20.
There is this matter after 4 weeks. Yes,
Number
21.
21.
In all these matters, whatever the stay or anything is there extent. Yes, 21.
21. Medical Adya.
not directed to file amount calculation for arrears of maintenance. Dispute between son and mother.
Hmm. Hmm.
The trial court initially granted 3,000 rupees per month.
Hmm.
But that order has been challenged by before this.
You are appearing for the son. What was the amount granted to the mother?
12,000 rupees.
12,000. What is your income?
But I am doing some petty business in my business. I also having my two minor children.
Hmm. How much you are paid as of now to your mother?
But the 2,50,000 mentioned in my memo.
Maintenance of rupees ordered by trial court as per the oral argument. Courts are calculated the maintenance at the rate of 6,000 from the date of additional
As well, lordship has already directed.
to till this month, 23 months, it comes to 1,38,000.
But balance amount 4,01,000.
When will you pay that?
But my lordship, my request was installment.
Huh?
Installment, my lord, I agree to pay the installment.
Installment means how?
Per month, my lord, my capacity, my structure of my claim.
No, no, with your monthly maintenance, when will you pay this 4,01,000?
But I ready to pay installment 4,00,000 rupees.
You should tell, if I say you should pay within 4 weeks, I will say 8 weeks. That's not, you will not be able to pay. What is, how you can pay this 4,01,000 in what time?
30,000 every month, my lord, is ready to pay 30,000.
What is the age of the mother?
But at the time of my lord, 50 years, 65.
50, which year is this RPFC? I mean, the criminal miscellaneous.
Criminal 2010.
What is happening from 2010 to 24? You are the only son?
Two daughters are with my mother. One government employee, she secured one job, government job. She is peacefully residing with her daughters in Mysore city. She is also having a building. According to her admission in the domestic violence case, she is having building. She also received some rent. But I am not for that, I am not paying my mother maintenance.
You have not inherited any properties?
Some properties are there.
Then?
I am not interested.
No, you are saying that your mother is peacefully staying with the, you are also peacefully staying with your wife and enjoying the properties that you have inherited from your family. So you have a responsibility to maintain her. And right from 2010 till now, you have not contributed anything to her, except this 1 lakh.
What is the statement of objection? Original petition, they stated she left the company of his husband and the petition is a long back. The affair of this petition looking by his father, he suffered from cancer from long time.
Your father is with you?
Father is not no more.
He's no more. Like all during his lifetime, he was with you.
Yes.
Hmm. So we can't say that this 30,000. When will it? Now, if I say this, you have to. This order is confirmed, reducing that amount from 12,000 to 6,000. If you don't pay, they will execute it. There can't be any order like this for this 6,000. If every month 30,000 you will pay on the arrears, how can there be an order like that?
I make a respect to submission for so far as arrears of maintenance 4 lakh is ready to pay 30,000 per month. In addition to that, your lordship has 6,000 maintenance in future month. Total 36,000.
No. How much it would be? How much is 4 lakh?
4 lakh 1,000 arrears of maintenance.
4 lakh 1,000. So in 1 year you will pay.
Yes.
Please come. Notice is served. The agreed with orders passed in criminal miscellaneous number 404 of 2010 dated 27 July 2024. The petitioner son is before this court. The respondent, the relationship between the petitioner is the son and the respondent is the mother. They are referred to as son and mother for the sake of convenience. The mother has filed the respondent mother has filed criminal miscellaneous seeking maintenance of an amount of rupees 15,000 from the date of the petition. It is her case that her husband passed away 2 years back. The son, at the instigation of his wife, deserted the mother and started living there separately with his wife and children in the house belonging to her husband. The mother is, as she is old and she is unable to earn her livelihood. She has approached the son and his wife with a request to maintain her. However, they have not allowed the mother to enter into their house. As such, she is constrained to file this petition. It is a case of the son that the mother has come before the court suppressing the two facts. It is a case that the mother has left the company and she was residing separately. She has neglected her husband as well as her children. The mother is residing at her mother's place along with her relatives since long time, during the lifetime of her husband. She has filed several false cases against the petitioner and his father and made them to suffer. The present petition is filed only with the intention to harass her. It is a case that the mother owns a house in her name bearing door number EWS 21 and 21A, consisting of 3 houses at Jayanagara, Mysore. And from the said property, she is getting sufficient rent and leading luxurious life. She has rented the properties and getting more than 10,000 to 15,000 per month. The court, by order impugned, had granted maintenance of an amount of rupees 12,000 per month. While passing the order, the court has observed that even though the son is having sufficient source of income and also acquired ancestral properties from his father and getting huge source of income from those ancestral properties, it's a bounden duty to maintain his mother for providing her maintenance. The mother, by using oral and documentary evidence, has proved before the court that after the death of her husband, the petitioner has deserted her and neglected to maintain her by providing maintenance to her. And accordingly, the court has held that she is entitled for maintenance. Next part. Learned counsel appearing for the petitioner submits that the petitioner, what are you doing? Is doing a petty business in Mysore city. He is not he has to take care of his two minor children and the wife. He is not having sufficient source of income. It is submitted that no doubt the petitioner has a responsibility to take care of the mother, but he is not in a position to pay an amount of rupees 12,000 as ordered by the court. It is submitted that the mother is having sufficient income. She is residing with his sisters who are her daughters, and only with an intention to harass the petitioner, the present petition is filed. Next para, though notice is served on the respondent, no wakalat is filed on her behalf. Next para, having got the counsels for the petitioner produce the material on record. The court had granted an amount of rupees 12,000. What is the basis for the court to come to the conclusion that what is the financial status of the son to pay 12,000 is not discussed by the court. According to the petitioner, the mother is having sufficient income. In that regard, no material is placed before the court. However, considering the fact that the petitioner has a family to take care, or petitioner, his two children, and the wife, 4 people, and considering the occupation of the petitioner, an amount of rupees 12,000 that is granted by the court is on the higher side, balancing the interest of both the parties, that is the son and the mother. This court deems it appropriate to pass the following order. The order dated so and so, passed by so and so, is modified, and the amount of maintenance from 12,000 is reduced to 6,000. The petitioner shall continue to pay 6,000 by 5th of every succeeding month, and the arrears at 6,000 shall be paid in equal installments within a period of 1 year from the date of receipt of the copy of the order, accordingly disposed of.
Cell number 22, Monisha NS for petitioner. Date Ananda S.
Respond.
Yes.
In this mediation report has been,
Mediation report is awaiting.
matter has been
Settled?
Yes, and the matter has been settled and both are agreed to divorce.
Live together. I'll record that and.
Not live together.
Huh?
They have
They have settled the matter.
Marriage.
There's a memorandum of
They
settlement.
have settled the matter. They have decided to live apart.
Live up.
It is submitted. Give that memo.
The copy.
It is submitted that before the mediation center, they have entered into a compromise and entered into a settlement where they've agreed to dissolve their marriage, solemnized on 11/9/2020. And they would not claim they agree that the wife, in view of the settlement, the wife would not press RPFC number 243 of 2024. In the light of the settlement that it is arrived on between the parties, dated 6/1. When is the settlement? 6/1/2025. The RPFC is disposed of. Yes.
It's a connected matter, my lord. It's a connected matter where we are the petitioner.
In second, this is RPFC 243. No, what you do is RPFC 243 of 2024 is filed by the wife. RPFC 207 is filed by the husband. Hence, in view of the settlement, the husband also do not want to prosecute accordingly. In the light of the settlement, both the RPFCs are disposed of.
Oblige.
Serial number
Yes.
23 adjourned. 24.
Yes, 24.
Serial number 24.
You that? Yes, maintainability of the appeal.
Maybe send to either. It's a Bidar district case, maybe referred to that Dharwad.
It has to go to Dharwad or Kalburgi.
Kalburgi means.
The writ petition, the office has raised the issue of maintainability.
My lord, this matter now, referring the matter, now it may not arise, my lord. This matter is pending for last some time. Recovery officer has already issued the.
We can't,
Now, my lord,
at liberty, they are at liberty to go before the DRT, I mean, to the Kalburgi bench. This maintainability issue is long back. That's why I have pressed it and I have taken it today.
Yes,
So we can't pass any order saying that when the appeal itself is not, petition itself is not maintainable, how can this court say anything else beyond that? The writ petition is filed, questioning the proceedings that are initiated. Where is it?
Now 15 crore.
Questioning the
My
orders
lord,
that are filed.
This is another way of my lord. This maintainability was noticed long back. The officers raised the objection. Now after 3 years, now amount due is 15 crores. Now it is now this being after 4 years, it is being referred to that another bench.
I am not referring. I am saying this is not maintainable.
Maintainable.
It is that if he,
Yes, my lord.
it is for him to take appropriate steps.
Yes, ma'am. Yes, that is all, my lord.
The same thing may be referred to the
No, my lord.
Kalburgi.
Referring, where is the question of referring?
Referring where it comes.
You file there.
It is not
If you are-
maintainable and
if you are-
dismissal.
If you are
That is all.
entitled to.
Yes, ma'am.
The present writ petition
The
is
list is, my
filed,
lord,
seeking
one
the
submission.
following prayer. The petitioner is a resident of Bidar. The bank is at Bidar. The industry is situated at Bidar. When in that case, the petitioner ought to approach the bench at Kalburgi, but he has come before this court filing this writ petition. This is a writ petition of 2023. The office has raised the issue of maintainability before this court. The office objection with regard to maintainability is sustained. This writ petition is not maintainable before this court. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail to approach the appropriate forum.
Limitation aspect, my lord. One observation may be.
Why should we? Why should we? When this aspect was in the year 2023, when the office has raised the maintainability issue, what were you doing from then?
That's because it was a DRT order from Bangalore. For that reason, we had filed it before here. Subsequently, the bench, it did not be listed after once it had come before this.
So that's your duty. You don't have to say that it is not listed. We can't help it. Yes.
Just a limitation aspect.
Why should we give this limitation 23 to 26 when you are not vigilant? Is it when it is on the face of it? Bank is at some
The
place.
list is, my lord, the list
DRT is always at Bangalore,
The
either
schedule
to the Dharwad bench or Kalburgi bench.
The list in this petition is, my lords. The list in this petition is the property which is not been mortgaged to the bank. They are trying to, there is an order stating that not to alienate.
If that is the endeavor of the petitioner, why is he keeping quiet from 23 to 26? When the writ petition is not maintainable, you don't even answer that query. If the writ petition is not maintainable, you would have said that let liberty be given, and you would have pursued it in Kalburgi. Yes.
Please, my lord.
What is this? Yes.
Serial number 25.
In this case, appearing for
Petitioner.
respondent bank. Petitioner also.
The petitioner has passed away, Your Lordship, has died. Petitioner has died, Your Lordship.
Oh, he's no more.
No more.
On last
So
date of hearing,
the
we
petition
make
has become-
submission. On last date of hearing, we make submission. They don't know about regarding petitioner. On last date of hearing, we made submission. The petitioner has been died, my lordship. For that reason, partly heard on last date of hearing, the matter is posted for hearing.
When counsel for the petitioner submits that the petitioner is no more, But the cause of action will survive, then they have to issue the fresh notification.
Yes, my lords. You have to see.
The petitioner is no more. And the regular counsel for the respondent submits that they have to initiate the first proceedings against in respect of the said property. And if the petition is agreed, it can always come before the court. Considering the same, the writ petition is dismissed.
Cell number 26.
Grateful, my lords.
Yes.
26.
Appearing for the petitioner, my lord,
Yes.
the matter may be disposed of with the liberty to approach DRT.
Lord, there are two interim orders.
Two interim orders. 23 interim orders enjoying.
Oh, please, my lord. Initially, interim order granted subject to deposit of 2.5 lakh, which they complied. Later, the interim order modified on 5/2/2024. 5/2/2024. My instruction is that is not complied, partly complied. And they sought before this honorable court, my lord. 6 months time may be given and kindly come to the prayer which sought before this honorable court. Only 6 months, my lord, kindly come to prayer at page number, my lord, 7.
Why should we give you liberty?
Their
Why should
prayer
we
is
give you
direct
liberty
respond to
now?
grant 6 months
What
time to
is
repay the entire
prayer?
debt.
We will dismiss it. I will not give you any liberty. Because this is not a forum where you can happily from 23 to 2026, you're enjoying an interim order. And now you say that a liberty should be given. Will not grant liberty. Direct the respondents to grant 6 months time to repay the entire amount. 23 we are in 26, 3 years. Will not grant. The present writ petition is filed seeking the following prayer. You want the senior to come or shall I pass order?
Pass the order, my lord.
An order, a coordinate bench of this court has passed an order on 19/12/2023. Please extract that. Then an order was passed on 5/2/2024. Extract that. Land counsel appearing for the respondent submits that the order dated 19/12 is complied with, 19/12/2023 is complied with. However, the order dated 5/2/2024 is partly complied. It is submitted that the petitioner who has come before the court with the relief that he requires 6 months time could enjoy the interim order and still not complete the payment for a period of 3 years. Land counsel appearing for the petitioner submits that the petitioner may be permitted to withdraw the writ petition with the liberty to avail the appropriate remedy. The next para. The prayer, as sought for, the submission as made by the land counsel for the petitioner. This court is not inclined to grant any such liberty. The petitioner has come before this court seeking 6 months time for payment and from time to time the interim orders are extended and he has enjoyed the interim orders for a period of 3 years and could stall all the proceedings. Hence, this court is not inclined to grant any liberty to the petitioner. Accordingly, the writ petition is dismissed. Yes, Mr. Shetty, what happened to the other case?
My lord, other matter, my lord, kindly come to, my lord, the last writ petition filed by the petitioner, that is at page number 31.
Cases I see. Cases I see.
Cell number 17.
Please, my lord.
Pass over.
Page number 31.
Page number?
31. The petition, my lord, it's a long checker history from 2010. In fact, my lord, this property has been sold by the recovery officer pursuant to, my lord, recovery certificate issued under section 19.
No, first of all, before that, when was the property mortgage?
My lord, that is the reason, my lord, I sought some time because that's transferred from branch to, my lord, ARMB. My lord, since
what I feel, Mr. Shetty, banks are very, very casual.
Eitherly, in this matter, my lord,
When
it's
it
not-
comes to, extracting or recovering the money, our approach is different. No, you have sold the property.
I have not sold the property, my lord. Recovery officer sold the property.
You
pursuant to
have
recovery
mortgaged the
certificate.
property. You have taken the mortgage.
May
Where is
not-
the due diligence?
It is may not, my lord, I'll just put it in this way. My lord. Under DRT Act, my lord, mortgage is not necessary. Even, my lord, identify property or any property belongs to the borrower, my lord, can be attached by the DRT and sell it.
In this case, it is a mortgage or not?
That I have to verify. Because recovery officer sold a property, according to me, my lord, it may not mortgage the property. It may be
Your
identified
Lordship,
properly.
this will be the fourth round of litigation, Your Lordship. First two round was by the borrower stopping the auction. Then it was by me asking for sale certificate
That's
to
what
be
I'm pointing
registered,
out
where
to you.
bank was a party. The directions were given by this honorable court to get the sale certificate issued in my name.
To the recovery officer.
Please, Your Lordship, this is my fourth round of litigation, Your Lordship.
Who represents only the?
My lord, the last date of hearing in the earlier proceedings initiated by the petitioner, the direction issued to the recovery officer, not to me. My lord, kindly come to page number
Who
30.
represents the recovery officer?
My lord, it's a central home standing also must be appealed. I think he should come before this court because money, I don't think so, my lord, bank taken 1 rupee in this matter. It is with the recovery officer. I'm trying to, my lord, take the instruction. I don't think so, money taken, my lord.
Money
I
is
think more fairness and transparency is required in these proceedings.
Please, I too agree, my lord. It is a sale conducted by the recovery officer.
Please don't,
He's-
don't pass on the parcel to the
No, it is
some
not
other
so.
person with all these liabilities.
No, it is not so, my lord. My lord, if the recovery officer appearing before this honorable court, he will be the right person to, my lord, answer my lord's query.
Who appears for the recovery
They
officer?
have
My
not.
lord, Mr. Kumar, Central Government Standing Council may take notice and I'll also inform.
So and so, give the full name.
Mr.
So
M.N.
and so is directed to take notice on behalf of the second respondent. What about fourth respondent? He'll represent fourth also?
Fourth, I don't appear, my lord. I think.
No, Union of India represents Reserve Bank of India, no?
No, they have a separate set of.
Take out the Bangalore or take out Handsome.
Please, Your Lordship.
On the fourth respondent.
Please.
And
Patridge appears for this.
Huh?
King and Patridge.
King and Patridge.
What is
They
that?
represent-
Law firm call it as
Law
King
firm.
and Patridge.
So and so is directed to take notice for fourth respondent. Fourth respondent.
Kurtini.
List this matter as part heard.
Grateful.
It may be taken next week. Next week, Your Lordship.
Service complete.
No, if I'm sitting next week, it will come.
Please.
Grateful. My lord, I think recovery of, before the recovery officer, that money is there. If they're entitled, my lord, my lord may direct the recovery officer to refund. Grateful.
Yes.
Sale number 27, Banu Prakash VG.
Your Lordship, one small submission, if my colleague is here, Your Lordship. One covered by judgment, it's the same issue where the bank and recovery officer both were directed. The entire facts are same, Your Lordship.
What do you want?
I just want if the instructions can be taken on that also, Your Lordship. It's a covered by judgment where in the same recovery officer and bank both were directed to refund the
What is
money.
that order? What is that order that you can tell?
Because Your Lordship, the onus is being now shifted to recovery officer alone. It's the bank and the recovery officer, both they have to.
What is the order that is passed? You're saying covered. What
Respondent
is
number
the
one,
order?
that is recovery officer and the bank both are directed to refund the amount to the
That
auction
is
purchase.
100% that will be done without the covered order also.
Please, please.
But first of all, we have to
I'll
find
serve
out
them.
why is it done?
I'll serve them.
We should find out the reason and we should also, the concern should also be, should give an explanation why things are happening.
Please, I'll get the
Yes.
instructions. Thank you.
Grateful.
Sale number 27, Banu Prakash VG.
I appeal for the petition in this case, my lord. My lord, the matter is still pending before the apex court.
Interim order is extended or not? When did it has come?
It has come last in January, my lord. I filed the memo last occasion to this honorable
Oh,
court.
it is extended
After
interim
that-
order?
Yes, my lord. After
Huh?
that, it's not come after that, my lord.
I'm asking in the month of January
Yes.
whether the interim order is extended or
Yes, my
not.
lord. As of now, it is extended, my lord. It came last.
This is matter in the month of March. Yes, next.
Sale number 28, urgent, 29. Egda Veena Shrikant. Raghavendra NR for respondent.
No representation. This is matter for dismissal. Yes.
Sale number 31.
30.
Sale number 30, Siddhappa BM.
My lord, last occasion, my lord, they undertook before this honorable court. They'll file an affidavit before this honorable court. Within how many days they are going to pay the entire money? Lord, the interim order is operative from 2024. They have not paid any money except, my lord, complying the interim.
No representation. This is matter for dismissal tomorrow.
Grateful.
May I please, my lord?
Yes.
I am appearing for the petitioner.
Yes. What do you say? Whether the interim order is complied with or not?
It is complied, my lord.
No.
Interim order complied, my lord. I am prepared to pay entire amount.
My lord, except complying the interim order, they
I
have
am,
not paid any money to the bank, my lord.
Then
From-
please argue on the merits of the matter.
May I make one submission, my lord?
Yes.
My lord, my party is prepared to pay entire amount. We are negotiating with the bank. We are granting some time to pay entire amount. So it is going on, my lord,
Any
negotiation.
option, my lord, assailed before this honorable court. Sale not taken place.
Because 77 lakhs is due. It is a education society. 2021, my lord, due to the COVID, you have suffered
Is there
some
any
loss.
one-time settlement for this?
My lord, no, they're not approaching, they're not given a one-time settlement offer, and my lord, I can't
The
consider.
petitioner, land council, the petitioner submits that they want to settle the matter. The petitioner shall approach the bank. If that is the
I'll
case,
just
the
interfere, my lord. Kindly see the order passed by this honorable court on
I'm
last date
just
of hearing.
giving one date. 8, I'll
Last
specify
date
the
of hearing,
date.
they said, my lord, we'll file an affidavit before this honorable court. That is, the order has been recorded by this honorable court.
Where is
We'll file an
that?
affidavit, last date of hearing. On my lord, 14-1.
Land council for the respondent submits that the outstanding amount as on today is rupees 77 lakhs and odd. And counsel for the petitioner submits that he is ready to pay the entire amount within a period of 8 weeks, and they will file an undertaking affidavit before this court. List this matter as parted. Where is the undertaking affidavit? Yes, Mr. Counsel. Where is the undertaking affidavit?
My lord, the petitioners, my lord, is negotiating because 77 lakhs is due.
I am
So
not concerned with that. On 14/1/2026, a submission is made before this court that you will come up with an undertaking affidavit.
That
List
is
this
my lord, in
matter.
order to file it, we are making efforts.
List this matter next week. By that time, if the undertaking affidavit is not filed, the writ petition will be decided on the merits of the matter.
In fact, sale is also not completed.
Huh?
May I request for 2 weeks time, my lord?
Nothing survive for consider. Sale SL before this honorable court, my lord. Sale not taken place. Nothing survive for consideration before this honorable court in this juncture. I have to issue fresh sale notice. That can be SL in a separate, my lord, application. Sale is challenged before this. Kindly come to the prayer, my lord. Issue writ of certiorari or any other writ or directions to the nature of the writ of caution. E-auction publication issued by the respondent bank, published in Kannada, dated 3/6/2020, scheduled to be held public auction on through the 3/7/2023. That is not taken place for want of bidders.
Yes, what remains in this writ petition? Nothing remains.
Your lordship, may that observation may be disposed of, my lord.
The present writ petition is filed. Seeking the following prayer. Then counsel appearing for the respondent bank submits that for want of bidders, the auction, as per the, he has questioned the position, wrong file is it? What is the number?
30.
Number, my lord,
24693.
24693, please, my lord.
But what you have read, I don't find it here. It's questioning the position notice.
Petition. My lord, one more petition they filed. It's disposed of. I apologize, my lord. One more petition they filed. That in that petition they challenged the sale notice.
Is he accepting whatever you are saying?
I'm so sorry. I apologize, my lord.
List this matter next week. By the time, if the undertaking affidavit is not filed, the writ petition will be heard and decided on the merits of it. Yes.
I'm so
Number 31.
My
May I
lords,
request
appearing,
for 10 days later, my lord?
Yes,
May I request for your lordship to 10 days later, my lord?
2 weeks. Yes.
My lord, they supposed to file, my lord, undertaking affidavit by today.
Next time, no more arguments.
Any
I'll
date
pass
may be-
orders.
Any date may be fixed, my lord.
No, whenever that's why I said
Next
2
Friday.
weeks. Huh?
Next Friday or
Friday if I'm sitting?
Friday.
Yes, Friday.
Wait for my lord.
Yes.
Cell number 31.
My lords, appearing for the petitioner, my lords, my senior is on her legs in another court, my lords. A short passover may be granted.
I will be raising now. The list is complete. Tomorrow.
My lords, if it may be given on Monday, my lords.
But there is some difficulty.
How is it possible Monday?
That's short point, my lord. My lord, the writ petition is filed assailing the order passed 2.5 years back. My lord. The impugned order is passed in 2022. Recording my submission.
You can appear online tomorrow. We'll post it because it is not possible
My
to
lords,
take today.
there is a difficulty tomorrow, my lords. If Monday it can be taken up, my lords.
Any other date?
I'll please request the Chief Justice for a sitting on Monday. The list is smarter after 2 weeks.
Grateful, my lords.
Done? Any passwords? It's not written. So she's expecting me to write. Hmm.
So sorry, my lord. Serial number 31, interim order may be extended.
Interim order will be extended.
Oblige, my lord.
Next Friday, preview. ಯಾವುದು? 2 weeks ಅಂತ ಹೇಳಿದ್ರು. ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಅಂದ್ರು, ಆಮೇಲೆ ಅವರು 10 days ಆಫ್ಟರ್ ಅಂದಕ್ಕೆ 2 weeks ಅಂತಾರೆ. ಯಾವ್ದು ಡೇಟ್? ನಾಳೆ ಕವರಲ್ಲಿ ಅದನ್ನ ತಂದಿರಮ್ಮ. ಅದೇ ಅದು ಸೈಡಲ್ಲಿ ಇಟ್ಕೋತಾರೆ, ಅದು ಇದು ಟೇಬಲ್ ಲೋಕ ಅದಾಲತ್ತಲ್ಲಿ ಕೊಡ್ತಾರಲ್ಲ, ಅದ್ರದ್ದು ಟೇಬಲ್ದು ಒಂದು ಸೆಪರೇಟ್ ಆಗಿದೆ ಅದು, ಪಾಲಿಥಿನ್ ಇದರಲ್ಲಿ ಕವರಲ್ಲಿ, ಅದು ತಗೊಂಬರಮ್ಮ.